Hey, thank you. Our second panel will explore issues of press exceptionalism that have been touched on, that came up briefly in the first panel. Panelists, the initial presentation will be made by Sonja West, who is an associate professor of law at the University of Georgia Law School. She's worked as a reporter in Illinois, Iowa, and Washington, D.C., and after going to law school, she clerked for Dorothy Nelson of the Ninth Circuit and Justice Stevens of the U.S. Supreme Court, and then practiced media law. Her teaching and scholarly interests are in media law, constitutional law, and the U.S. Supreme Court. The commenters on the initial presentation are RonNell Andersen Jones, who is an associate professor of law at Brigham Young University. Now, I guess, not really, this is not an endowed school, but it is the J. Rubin, where she teaches constitutional law, First Amendment, and media law. She clerked for Judge Betty Fletcher on the Ninth Circuit and Justice O'Connor on the Supreme Court, and worked as an attorney at Jones Day on First Amendment, Supreme Court litigation and First Amendment issues. She too is a former newspaper reporter and editor, and she writes on issues affecting the press and the intersection between media and the courts. And then David Andersen is Fred and Emily Marshall Wolf's Centennial Chair in Law at the University of Texas Law School. He has co-authored casebooks on mass media law and on courts. The selection effect that I mentioned earlier. He too worked as a political journalist and political editor for 7 years, and is an international speaker on free speech issues. Wes.
Okay, thank you so much. I'm so happy to be here, particularly since about 48 hours ago it was looking really sketchy if I was going to make it, since this, what we were told was historic ice storm was coming through Georgia, where I live, and luckily it was not quite as bad where I live than they feared, and there was just enough of a window before we hit the storm coming today here. So I'm very pleased to do that. And I do want to thank the Harvard Law Review for putting together the symposium, for Olga and Roni for inviting us. And I also really want to thank David and RonNell. I'm honored that they took the time to read my piece. I'm looking forward to their comments. They're two of my most favorite, most respected press scholars, and I couldn't be more pleased to have them here today. So this piece is a follow-up to an earlier article I wrote in which I argued that defining the press for purposes of the First Amendment press clause is something that is both necessary for us to do and achievable. Specifically, I argued that we should think about defining the press more narrowly, that our instincts that we have typically toward constitutional overprotection, at least when we think about speech issues, are not necessary and actually a forfeit when it comes to thinking about the press clause. And ironically, this drive we have to give broad protections, First Amendment protections, to everyone when we think about the press has actually resulted in us having less constitutional protection for the press. So I pick up on these thoughts here, and I start in this piece with this premise of, as I call for the title, press exceptionalism, that there does exist a subset of speakers who fulfill a distinctive role in our democracy, and that this differs from the roles filled by garden variety speakers. In my paper, I focus particularly on two groups of speakers, the press, and I'll talk a bit more about who they are, and also what I refer to as occasional public commentators. And these are non-press speakers who occasionally use their speech rights in ways that can kind of look press-like. So your first thought might be a little bit about, does this even matter? That we have extremely robust speech rights. What would we even gain by recognizing constitutional rights and protections for the press? And I don't pretend here that I'm entering into the task of figuring out the details of what kinds of potential press clause rights or protections we might want to consider But the potential need is most evident, as others have noticed as well, in the context not of speaking and publishing and broadcasting, but in the context of news gathering. The court has never protected a specific press right in the context of gathering information for the news. Reporters have no constitutional protection from, as we know, subpoenas to testify about their confidential sources or their personal observations that they may have had while gathering the news. They have no constitutional protections from being forced to turn over notes, work product. As we saw recently with an issue involving the Associated Press reporters, again, no defense against having their telephone records divulged, no First Amendment defense against having their newsroom searched. We also don't have any special analysis when it comes to minor tort violations like trespass, fraud, breach of duty of loyalty, things that come up in the context of undercover reporting. We also saw in another recent case involving a Fox News reporter that a journalist who receives leaked information as part of their news gathering could be treated as a criminal under certain circumstances. We also have no unique considerations constitutionally for the press when it comes to access to government information or places or meetings. Our policy is if we can't open the door to everyone for any reason, we don't open the door at all. Now, David has written a terrific piece detailing how we've had a number of non-constitutional avenues that have come up, legislative and executive action, that offer some legal protection for the press in some of these areas. But it raises the question of whether these protections are sufficient, whether we are satisfied with the press that function at the pleasure of the other branches of government that is checking, and whether these non-constitutional solutions give sufficient respect to the rest of the press. I think, again, we see the potential need for the issue here just yesterday. Reporters Without Borders came out with its world rankings of journalistic freedom, and the United States has fallen 13 spots to number 46 out of 140 countries that they looked at. So that now places us after some countries like Latvia and El Salvador and Romania. We did just this week ahead of Haiti here, so we got that. So that's my argument. I think this is something we should consider, and that there is a potential problem. In this piece, I focus on 2 points. First is the impact of our mass communication technology, particularly obviously the internet, on this question about whether and how we might go about separating the press from communication on public commentators. And then I end with some initial thoughts about a workable and constitutionally based framework for how we might identify the press. So first, the issue of technology. Obviously, we have this explosion in mass communication technology. It is now easier and cheaper for all of us to share information with each other. And this allows all of us to act, at times anyway, in sort of a press-like manner, which means we can share information with a potentially broad audience about matters of public concern in a timely fashion. This used to be what we relied solely on the press to do. In other words, we might be walking home from lunch and see a traffic jam and tweet to all our friends that we saw a traffic jam. This fits all of these criteria. Or we might go on our blog and opine about an upcoming election. So it raises the question of, are we now all the press? And there are a number of other commentators who say, yes, if there ever was this distinction between press and non-press speakers, it is gone now. We have entered the age of the state and citizen journalists. I push back on this idea. I believe that there are significant and important differences between the press and simply an army of individuals with internet connection. Chief among these differences include things like a proven track record of publication, an established audience, and a fulfillment of unique constitutional press functions, which include gathering and conveying newsworthy information and checking the government. And that the press does this in special ways by bringing unique expertise, resources, and again, this proven track record of fulfilling these functions. So the problem this technology brings, in my opinion, is not eliminating this distinction between the press and everyone else, but simply blurring the line between the two. But technology also promises some advantages. First of all, it makes it clear, if it wasn't clear before, that we must focus on function. We can no longer rely on proxies like do you communicate via the newspaper or radio or television. These used to be good indicators. Non-press speakers didn't have access or rarely had access to these means of communication, and press speakers had few other options in order to reach their audiences. Obviously, that's just not the case anymore. Everybody, press and non-press alike, uses the same tools, Twitter and blogs, to reach their audiences. So the technology makes it clear we really do, of course, need to focus on function. Technology also, I think, addresses one of the largest criticisms, long-standing criticisms, of singling out the press for constitutional protection. And that is that the concerns of elitism. That by doing this, we would be giving a privileged status, a privileged constitutional status, to a few elite speakers. Technology will make it, however, cheaper and easier for all speakers to be able to do the things it takes to reach press status, reach a large audience with a regular publication status, fulfill these functions, and they can do so without a news affiliation, a broadcast license, or simply personal wealth. So I think it helps in terms of equalizing these concerns. So I argue, rather than making us fearful of wading into this debate, the internet age is actually an ideal time for us to reconsider how we can breathe life into the press clause. So, accepting that the press clause should have a meaning that is independent from the speech clause by considering the unique role of press speakers, that's step one. Step two is figuring out how we identify these press speakers as opposed to non-press speakers. And this is, second part is what I attempt here, but I do so first with some disclaimers. The first disclaimer is that ambiguity or uncertainty does not sound the death knell in constitutional interpretation. Our Constitution is, of course, filled with unclear texts in other areas, yet nonetheless, in those other areas, we nonetheless have gone on to have clauses have a meaningful existence, even though there are, of course, gray areas. This concern, in my opinion, is actually lessened with the press clause than it is with some other constitutional provisions because of the speech clause and its robust rights. It provides a fallback protection that make the requirement that we have line drawing perfection less vital. So my second disclaimer is that I believe the burden at this stage is not to provide an immediately clear answer for every conceivable hypothetical case that could come up. Constitutional interpretation, of course, proceeds and evolves slowly on a case-by-case basis, and the aim here is simply to rely on existing frameworks and to think about a way forward. So in building the framework that I suggest in the paper, I rely on two primary sources for guidance. First, for constitutional grounding, I looked at the Supreme Court's unanimous 2012 decision in Hosanna Tabor versus the EEOC. Now in this case, in Hosanna Tabor, the court was charged with trying to figure out whether a parochial school teacher was a minister for purposes of the ministerial exception to the free exercise clause. The disclaimers I just made, by the way, the court made pretty much the same ones when it entered into this task in Hosanna Tabor. And some interesting things about this case are that, first of all, not only did the court there conclude that it could identify certain individuals and organizations as constitutional right holders who fulfilled unique First Amendment functions, but the court in that case also said that it must and had a duty to distinguish these particular actors because otherwise they would not be giving full meaning to the text of the First Amendment, which the court told us, quote, gives special solicitude to the rights of religious organizations. Obviously, I think there are strong parallels to the task of thinking about the press. Second, and my other source of guidance for practical considerations, I examined statutory attempts to define the press. And in my last article, I looked at what legislative bodies have been doing and examined the strengths and weaknesses of their different approaches. So there really are two questions here. Who are the press, and how do we find them? So as far as the who question, I would simply argue that the press are those speakers who perform, a bit circular, I understand, the constitutional functions of the press. A functional approach to the press, of course, would mean you are the press because you are acting like the press. It clearly has a lot of advantages that many commentators before me have noted. It helps with the blurred line with technology, as I mentioned before. And this is something, again, that the court did in Disseminator. They concluded that this woman was a minister in part because she was performing ministerial functions, like being prayer and teaching religious services. So what are the functions of the press? Other commentators have attempted to talk about this. They have proffered what those functions are, simply told us editing and publishing. They came up with a variety of lists. Others have looked to journalists to tell us what the functions of the press are, some to legislators. And another piece I have coming out this spring, I suggest that the most theoretically sound place to turn to is what the Supreme Court has told us repeatedly and consistently are the constitutional functions of the press. Because while the court has not recognized any press rights, it actually has talked about the press a lot, almost always in dicta, as RonNell has written about in another piece. But they nonetheless have told us a great deal about what the functions of the press are, far more than, for example, they have told us what the function of, say, religion might be. And the court, when you look at all of the cases, has made it clear that the press has two unique functions that seem to differ from other types of speech, and those are gathering and disseminating news to the public and serving as a check on the government and the powerful. So the second question then would be, how might we find the speakers who are fulfilling these functions? And again, ultimately, like Disseminator, I think we see a path for a holistic approach that looks to not only whether the actors are fulfilling these functions, but also examines other factors, none alone, which are alone decisive, but seem to be reliable proxies. I'll mention just a couple of these and focus on just a couple in the interest of time. The first is recognition by others as the press. In Disseminator, the court relied on the fact that the church had held the teacher out as a minister, including giving her the title of called teacher as opposed to lay teacher. This is in keeping with the concept of institutional theory advanced by scholars like Frederick Schauer and Paul Horowitz and others. It's a simple idea that when society is left alone to build its institutions as it sees fit, the courts can and actually should look to those institutions as guides in interpreting the law. Now, obviously, we don't want to rely exclusively on institutions. We would not rely exclusively on churches and religious institutions, for example, to tell us who can and cannot exercise claim a free exercise clause protection. But it would also be imprudent, the court tells us, to ignore them. That, in other words, we have a pretty good idea who our minister is because the church tells us they are. By the same logic, if our goal is to find press speakers listening to our press institutions, our news organizations, our professional journalism societies, and other groups that credential the news, media, or confer journalism degrees, will help us go a long way in finding them. Again, this would not be the only factor. In order to ensure that we have a variety of viewpoints and speakers, there must be other paths to press recognition. But that doesn't mean that we can't let the press institution do a large amount of the heavy lifting for us. So the flip side of that would be self-identifying as the press. Again, in Disseminator, the court relied on evidence that the teacher had held herself out as a minister. This would, of course, require more scrutiny than third-party recognition, but taking into account speakers who have held themselves out as members of the press, which shed some light on issues of intent and also reliance by others. Another factor in Disseminator was training and education. I think that also applies in journalism. A background of training or education or experience in journalism is another way of really taking advantage of third-party signaling. But finally, and perhaps I think most uniquely to my argument, I suggest that courts look for regularity of education and an established audience as being part of a press. I think that these factors are important because they correlate closely to the unique constitutional functions of the press that I mentioned before. If the press publishes or broadcasts news and nobody hears them, have they really functioned as the press? And this is an area where thinking about the press does differ from speech considerations, where in addition to information sharing, we also value things like personal autonomy and self-realization. Effectively delivering newsworthy information to the public requires actually connecting with an audience. At the same time, serving as a check on the government and the powerful will not be effective if it doesn't reach the public and an audience. And it also helps us separate out the sporadic public commentator who may occasionally act in a press-like manner from the repeat player who is devoting time and resources to press functions. It also helps us in terms of ensuring accountability. The court has told us in the RonNell case, in the CBS versus NC case, that while the press checks the government, the checks on the press are their reputation and their readership. And without the demands of regular readers over time, we lose this check on our journalistic reputation, our journalistic enterprise. So what this means is that, of course, nobody can wake up one morning and be the press. Rather it is a status that is gained over time and with effort. And when I've talked about this in other audiences, for some reason, this really seems to bother people. And I get a lot of pushback from it. And I think it's because, again, it goes against our instinct to be constitutionally overprotective. This is the approach we've been taught, and I think we all like on Facebook, in terms of speech, and for important and I think valuable reasons. And again, there's also a concern that it raises elitism, that there's only certain speakers. I, of course, don't think it warrants this concern, as I wrote about more in my last paper, unlike with the speech clause, where I think there are real dangers of excluding particular speakers or viewpoints from our debate, silencing, because with the press clause, all speakers retain their speech rights. We don't have the same concerns, and I think relying on regularity of publication and an established readership actually helps concerns of elitism. Circling back to my point about technology, far more people now have this ability and means to publish regularly to a broad audience. Sort of the modern blogging story would be, of course, our most obvious issue. Whereas once upon a time, if you didn't have access to a printing press and the money and literacy to use it, you were hard-pressed to be able to get your message out. So to me, what is important is not that everyone is the press, but rather that everyone has a path up to becoming the press. So giving meaning to the press clause, I believe, requires tackling the problem of who or what is the press. To do this, we need to embrace the reality that we are not all the press, but rather there is a narrow category of speakers who are fulfilling a unique constitutional function. And then the next challenge would be to have the confidence that we can identify those speakers with sufficient, albeit not perfect, specificity. And I think the court showed us in Kasana Tabor that we can do this and that we must accept this challenge.
Okay, well, my sincere thanks also to Olga and Roni and the other editors of the Harvard Law Review for organizing this great event and especially for inviting me to participate. I'm really delighted to be here and especially delighted to have the chance to comment on my friend Sonja's latest, I think, really interesting contribution to what I see as a really important ongoing conversation about the metes and bounds of the First Amendment's press clause. I'd like to direct my comments to this analogy that Sonja has proposed for differentiating this specific extra protected subcategory of the press from this broader, less protected category of occasional public commentators. This model that is based on the approach that the Supreme Court employed in demarcating the category of ministers in the Hosanna Tabor case. The truth is that Sonja and I disagree quite infrequently, and at the 33,000-foot level of sort of what our broad macro goals ought to be on this, I think that our views are almost almost totally aligned. But in the interest of providing some useful feedback, I have decided to focus on this area where I do think that I can push back at least a bit to help hone our thinking on the endeavor that we both think is so important, and maybe to help advance the conversation that I think she so smartly started with this particular choice of analogy. So I'd like first to offer some comments on why the Hosanna-Tabor analogy is an appealing one, and then maybe launch into some discussion of what drawbacks or concerns we might have about that particular model. All right, then, so there are what I see as three primary upsides to the approach that Sonja has taken in building an analogy to Hosanna-Tabor and its definitional structure. The first, and I think so importantly, is that her Hosanna-Tabor model does make the critical point that we do not simply throw up our hands or abandon a definitional endeavor because it is complicated or difficult or potentially multifaceted or growing over time. I agree with her that it is just analytically weak to say, you know, because this definitional question is hard to iron out, we won't give any substance to a constitutional right. Courts are in the business of constructing guideposts and drawing lines in cases over time. Now, if Eugene Volokh and Mike McConnell are right that the press clause wasn't intended to carve out a unique protected group and instead was intended only to speak to the breadth of communication technologies that all speakers would be able to use in exercising their expressive freedoms, that's of course a reason to shy away from the endeavor of defining the boundaries of a uniquely protected group. But I don't find it to be compelling even as a supporting argument that we should gravitate to that view merely because it would be the definitional path of least resistance. And I think Sonja's Hosanna-Tabor example goes a really long distance towards sort of demonstrating this, that difficulties in definition shouldn't be a deal breaker in defining operating a legal rule that needs to identify a group. Second, I think that the Hosanna-Tabor test might be appealing, at least at first blush, because it contains some components that are more heavily task-related, functional in nature, and thus arguably have a broadening effect, and some components that are focused on things like historical identity or external recognition or other kind of labeling questions that I think of as more formalistic and that arguably have sort of a competing narrowing effect. And the balance between these competing components might be really important and alluring in these debates over, you know, who the founders envisioned would have these rights and who as a normative matter ought to have these rights. And so while in a moment I might push a bit on the difficulties that might arise under some of the considerations in their specifics, I do want to compliment Sonja on her effort to try to find through this Hosanna-Tabor model, sort of a role for both looser functional components and more formalistic identifying components. Third, I think the Hosanna-Tabor model resonates as a useful analogy to the press definition context because the inquiry there, like our inquiry here, arises in a First Amendment setting in which we really have a goal of allowing a certain set of ideas or communications to develop free of governmental interference, and in which the sort of free development of those ideas depends on certain institutions. And I think this insight that the religion clauses might be a rich vein for considering how to do the job in the press clause context feels like a very important contribution that Sonja is making. Defining the boundaries of rights is dicey business, and I think there's an argument to be made that defining rights in these areas where institutions need to get special constitutional protection in order for those rights to flourish is a task that carries even more layers of complexity. So I do think that the inquiry into how we do this with religion is a really clever place for us to be turning for at least some insights into achieving our rights-based goals related to the press, once we've accepted the premise of her first piece that there will be an institutional component to the rights equation. Okay, so spurred by Sonja's really interesting idea that we do this comparison, I've done some more thinking about the ways that the two do and do not line up. And as attractive as the Hosanna-Tabor approach is in the abstract, I do want to make a few suggestions on ways that I think it might fall short of offering a perfectly apt analogy to our task of identifying the press. That is, some ways in which defining a minister in Hosanna-Tabor is enough different from defining the press in the cases that Sonja is considering that the comparison may break down in ways that matter to our job here. And although I think that some of these disparities cut in really weird different directions, I do think that they mostly signal that a very task-focused functional inquiry might make more sense, and any component of formalistic labeling might make less sense when we are thinking about the press instead of about ministers or religion. Let me outline just a few of these differences. First, the reason that we needed to develop a definition of minister and the reason that we now need a definition of the press are in some respects opposite. So recall that if someone is a minister under the court's Hosanna Tabor definition, he or she is deprived of the protection of Title VII, whereas if someone belongs to the press, the consequence is that he or she gets additional constitutional protection. And I think that that fundamental difference might mean that some of the key considerations that make sense in Hosanna Tabor make less sense in the press definitional context, most notably the external recognition and the self-identification pieces. When you self-identify as a minister, there are costs, most notably not being protected by employment discrimination laws. So there's some very good reasons to take self-identification seriously, but it may be less helpful when trying to decide the press definition rubric because what's at stake is the gaining of a constitutional right. And whatever else this does to change the equation, it unquestionably compounds the really serious problems that Sonja already acknowledges carefully can exist with self-identification. For example, the risk that labeling can pretty swiftly swallow up all the other characteristics, or the risk that reliance on self-identification would incentivize everybody to self-identify, thereby breaking down the boundaries of the rule. But it also does almost nothing to alleviate the kinds of risks that might be faced if we focus on external recognition rather than self-recognition, as Hosanna Tabor also suggests is useful. Because again, the unique situation of the developing American media really does put some wrinkles into the approach. I think that there is a very real concern that we have to tackle, that relying on press organizations' recognition of the press to identify the press will necessarily favor old media, because the old media still likely control the membership and the educational trajectories, and might have, created built-in problems of path dependency as these, legacy professional organizations skew their guidelines to burden particular newcomers. The flip side of this, of course, is the related risk that will end up unfairly disadvantaging non-traditional news sources that are unquestionably fulfilling what we think of as the core constitutional press functions. Second, I also wanted us to think some more about how the analogy to Hosanna Tabor might be a tricky one, because in that case, the Supreme Court didn't actually decide the question of what is a religion for freedom of religion purposes, but rather who qualifies as a minister in what we assume to be a religion. So in that regard, Hosanna Tabor says very little about what qualifies as the press for freedom of press purposes. Hosanna Tabor might be more relevant to sort of the question of which employees in an organization that is assumed to be the press is a reporter. But it doesn't go the full distance and sort of address the fundamental question of what is the object of the guaranteed freedom, religion under one clause and press under the other. And this makes the analogy a little bit apples to oranges, or I guess, right, if we're being honest, sort of like apples to apple seeds or something. It's almost the right question, but not exactly the right question, and that might matter to us in how far we're willing to take the analogy. So if we tied the analysis of who is a member of the press in any way to an affiliation with a press organization, we're necessarily going to beg the question of what is a press organization. And the problem we have here is that Hosanna Tabor doesn't really squarely answer that initial root question. Significantly, in the free exercise context, courts have struggled with and largely tried to avoid the definition of what will count as a religion. It's true that in that area we put a lot of constitutional value on the individual sincerely self-identifying with an apparently sincere religious belief, but the real weight of the analysis is on what she sincerely believes in. That is, on this very, very functional question of whether those beliefs occupy a place in the life of their possessor that's parallel to the place filled by the more orthodox belief in God of more traditional, obvious religions. So in deciding whether this thing that she self-identifies with is a religion, we're doing a heavily functional investigation. Does this entity do the kinds of things that are religion-y, and not a labeling question? So if we're comparing apples to apples, that is, if we're instead modeling our inquiry on how the court defines religion rather than on how the court defines minister in a religion, the task-related functional questions of what the alleged member of the press is doing and how it parallels the goals initially envisioned for the most obvious category of the press at the time of the founding might have a larger or potentially decisive role and might trump things like self-identification or external identification. Third, Another consideration here that might cause us to think about how well the tools in Hosanna Tabor align with our press identifying task is this really unique pressure that's created by the existence of two religion clauses in the First Amendment. So because there are two separate religion clauses kind of tugging on each other, but only one press clause, there's something of a structural element to Hosanna Tabor that is just not present in the press clause context, and that might make an important difference in the scope of the court's definitional role. So the court in that case faced not only an argument about free exercise rights, that is, that the ministerial exception is a group right under the free exercise clause, but also arguments based on the establishment clause, that is, that because of possible structural adjudicative disabilities that are created by the establishment clause, the government lacks the power to tell the Lutheran Church who it must hire as a minister under Lutheran theology. Now, this question of whether the establishment clause is jurisdictional in some way and thus not subject to balancing like the group rights focus of free exercise, I think is still being hotly debated, but the court in Hosanna Tabor, although somewhat confusingly, does seem to be drawing a little bit on both religion clauses. And there's nothing like the establishment clause, driving the bus or co-driving the bus, as the case may be, in the press clause area, where we would in fact be squarely focused on questions of group rights and the attendant questions of who possesses those rights and what kinds of interests are compelling enough to trump them. So the religion context, in the religion context, the court, I think, may be avoiding this purer task-related functional inquiry, even if it thinks it's a better tool for figuring out who's doing the job of minister, just because it has decided that it's a tool that it can't employ because it would constitute such significant meddling in the affairs of the Lutheran Church that the establishment clause would bar that inquiry. All of this is interesting in the press clause context because no such constraint exists there, where we really remain free to take the purer task-related functional approach if we decide that it does a better job of telling us who warrants the protection. And it may make a substantial difference, I think, to whether we can repurpose all of the Hosanna Tabor factors to answer questions about press membership. Finally, I just want to throw out a point about an ongoing debate about the reasons that the First Amendment protects religion, and the ways in which those might at least arguably be different than the reasons that the First Amendment protects the press. Freedom of religion, the free exercise of religion, is protected at least in significant part because it is a matter of personal conscience and self-identity. Certainly there are those who have argued that it has a more practical role of giving the adherent a positive identity to buffer her against the state. But largely, I think, we believe that the government can encroach on your religious freedom because it's an unconscionable intrusion on your being. To have the government interfere with what is really a central, personal, freedom of conscience variety of right. Conversely, because the press is protected for far more functional reasons, as Sonja, I think, aptly describes here, that is, it is protected because of what it is doing, a heavily or even completely what is this person doing functional approach might make sense in the press context in ways that don't make sense in the religion context. We know what we want the press to be doing. Sonja's done an admirable job of describing the news gathering, dissemination, watchdog functions, this role of serving as a check on the government and the powerful, and of being a surrogate for and conduit of news to the public, and more specifically, as she mentions earlier in her piece, doing what she calls gatekeeping, right, sort of for a particular community, geographic or otherwise, in a way that structures the shared conversation through an exercise of valuable editorial judgment. And I think we can and should debate the specifics of what belongs on that definitional list a great deal more, but my point is that maybe the task list drives us much more here in the press area than it drives us in religion, because the point of giving the press special constitutional protection is to allow them to do what we want them to be doing. And conversely, as a constitutional matter, although still debatable, it is arguable that we don't necessarily know what we want churches to be doing. Because it is a freedom of conscience variety of right, they're sort of supposed to be able to define their own purposes and practices in a way that doesn't jibe at all with the very outcome-oriented reasons that we think that the press gets constitutional protection if there is some there for them. So all told, I think there's a possibility that all of these differences might point us in a direction of needing to think much more carefully about giving a primary or even exclusive focus to the task-related functional inquiry in creating these definitional bounds for the press clause coverage. Let me say again that I really think Sonja does important work in getting us thinking about the kinds of components that speak to those functions, and especially in highlighting the utility of religion clause jurisprudence in sort of enlightening that inquiry. So moving ahead, even if, as I've argued, the Hosanna Tabor minister analogy falls a little bit short of giving us perfect guidance in at least some of the realms, I do think that we'll be able to build on this foundation to create a critically important edifice for giving some constitutional protection that appears to be warranted for some of society's most significant actors. Thanks for your time.
Well, obviously, we're the kind of people that Mark warned you about. We're not only adherents to the theology of the First Amendment, we're captured by a sub-agency. We're all fans of the press clause. And I have the problem that Stuart Benjamin alluded to of, okay, how do I say something that's not just going to be endorsing what Sonja and RonNell have said? I've struggled to do that, and I think what I want to do is I just want to question the rationale that Sonja uses for press exceptionalism. I agree that the press clause was intended to have independent significance. I think it should be given independent significance for many of the reasons that Sonja mentions. But I think she has missed what it is that makes the press worthy of special treatment. She identifies the press as a subset of speakers who perform the unique tasks of informing the public and serving as a check on government and the powerful. But the press is not unique in performing those functions. Lots of others do as well. Let's take news gathering, for example. Most of what the press reports is information gathered by others. This is true of newspapers, television, magazines, and websites. Most crime reporting relies on information gathered by the police, the prosecutors, the defense lawyers, and judicial proceedings. Most reporting about more complex forms of wrongdoing, such as securities fraud and collusive bidding and fraudulent bank dealings, that's usually uncovered by government regulators or government investigators. Information about fires and floods and natural disasters, that comes from fire officials and law enforcement and relief agencies and so on. News about the economy is gathered mainly by the Commerce Department and the Labor Department and stock exchanges and the Federal Reserve and so on. A great deal of news comes from scientists, economists, medical researchers, and other experts who do studies that are reported on by the press. News about demographics and lifestyles and fashions and spending habits comes from vital statistics offices, Census Bureau, industry, and trade groups. To be sure, the press adds value by making the information more easily digestible or by providing comparative perspective on these reports. And some of the news gathering that's done by others occurs because the press is there to give it an outlet. An agency generates a report because it seeks the publicity that the press will give it. A prosecutor collects information about a suspect because he knows the press wants it. Of course, in addition to reporting information gathered by others, the press reports news that enterprising journalists uncover on their own. This is one of the ways the press serves as a check, as both of the previous speakers have mentioned. Investigative journalists expose venality, waste, inattention in government, business, education, healthcare, and so on. And our history is full of instances in which enterprising journalists have done very valuable public service in this regard. But increasingly, as the staffs and resources of legacy media are decimated, those functions are being performed by others. not just WikiLeaks and whistleblowers, but independent organizations like the National Security Archive, for example, who have the expertise and the resources and the staying power to investigate things that are too massive or too impenetrable for journalists. The press also serves as a check by serving as a watchdog, providing what Justice Stewart called organized expert scrutiny of government. But the press is rapidly abdicating that role, closing Washington bureaus, withdrawing reporters from state houses, from Congress and federal agencies, reducing coverage of city halls and courthouses. The metaphor of a fourth estate keeping an eye on government is of diminishing contemporary relevance. The watchdog role has been largely ceded to interest groups. The watchful eyes of the National Rifle Association or the Sierra Club are more likely to serve as a check on public officials today than the press. The press as disseminator. Well, once the press was an essential disseminator of news, but that's no longer true, because now everyone who gathers news has the capacity to disseminate it on their own. The ability to disseminate, though, is not the same thing as the ability to engage an audience. And this is where the press's distinctive value lies today. The press creates communities within which democratic dialogue can occur. Without some core of shared information and common purposes, there can be no meaningful discussion of public issues. If bowling alone is sad, talking alone is pathological. There are other ways to connect audience and news, of course, and some non-press agencies are ready and willing to do so. Providers like Google, for example, are very good at delivering news selected solely by the reader's previously demonstrated interests. Many of the legacy media are also rushing to embrace this concept of personalized news. But a polity in which citizens are attentive only to their own individual interests is not a polity at all. It's like a town meeting with no moderator and no agenda. Freedom of speech may be maximized, but to no common purpose. Democracy requires dialogue, and dialogue requires some agreement about the subjects to be discussed. What the press does, usefully if not uniquely, and RonNell alluded to this, is to organize public dialogue. News outlets sift, select, and package the news. That infuriates some people. But in so doing, they create a community among people who share at least the outlet's conception of news sufficiently to subscribe, to tune in, or to click. This is what some people most dislike about the press, of course. They view the press as an elite deciding what the public agenda should be. That's what it is, of course. Website operators, news directors, editors decide what to give their audience, constrained only by their own editorial judgment and the need to hold or expand an audience. But that's the way organized society works. School boards decide what children should learn. Universities decide what to offer their students. Preachers decide what spiritual nourishment their flocks require. Perhaps the press is not the only entity that can organize democratic dialogue. Political parties may do the same thing. Some of the same functions at least. Interest groups, religious organizations may also do so. Maybe other mechanisms will evolve as our brave new world of communications develops. But for now at least, the press is the principal organizer. I want to talk about freedom of religion in a slightly different way than RonNell has talked about it. I do think freedom of religion is analogous to freedom of the press in this way. Organized religion is by no means the only source of the values that the religion clauses protect. When the framers chose to protect freedom of conscience by protecting freedom of religion, it was not because religion does anything unique. There are other sources of spirituality, other guardians of morality, other belief systems. But in the 18th century, the church was the obvious and principal keeper of those values. We continue to give religion special constitutional protection and deny it to these other keepers because religion is the one the framers told us to protect. Like the press, religion is hard to define. Religion now takes many forms the framers could not have imagined. By singling out the spiritual source most familiar to them, they succeeded in preserving a sphere for spirituality and freedom of conscience. It is not commodious enough to protect all that we might include today if we were starting from scratch. But it does set aside large tracts where the state is not allowed to meddle. Similarly, the press clause need not protect all who now serve functions that might be thought of as press, but it's important to protect at least some of them. My difference with Sonja may seem like a quibble, but I actually think it's important. We both want the press clause to do some work, such as protecting confidential sources and guaranteeing some access to war zones or prisons. But I believe that it disserves the cause to ground the argument in the claim that the press is unique. The stronger case for constitutional protection of the press rests on its role as an organizer of democratic dialogue. The case for press clause, for enforcing the press clause, is not dependent on any belief that it's unique. And insisting that there is something unique about the press invites rejection of demands for enforcement of the press clause. Thoughtful skeptics look for functions that the press performs uniquely, and if they find none, they reject the claim for enforcement of the press clause. It is enough that the press is one of the entities that serves these functions, and it's the one the framers anointed. Protecting them all, protecting all the people who serve those functions, would be impossible, but protecting none of them would be intolerable.
Just quickly, sure. Thank you so much for both of us. First of all, RonNell is absolutely correct that, of course, Hosanna Tabor is not a perfect analogy, and I think the primary quibble that she said is obviously the difference between sort of right-seeking versus the risk of being put in a less favorable position. But I do think, in a lot of ways, approaching the problem of defining the press is actually a far easier one than with religion. So showing that they were able to tackle at least this one piece of the religion puzzle in Hosanna Tabor, to me, it gives us great optimism that we should have lots of confidence going forward with the press, because, as RonNell said, with religion, we're very concerned about stepping into this realm that's very personal, this matter of conscience. The court, for very correct reasons, is concerned about, stepping in this area that's something that we just can't have be subject to a legal system of what your religious beliefs are and whether they are important or enough. I don't think we should be as concerned about that with the press, because I do suggest that the constitutional protection for the press clause, different from the speech clause, is a very functional one. It's something we can rely on our courts to have more capabilities of doing, as long as we make sure they are not doing it for content-based or speaker-based or viewpoint-based reasons, that they have this capability of deciding whether this is fulfilling this function without these concerns of personal matters of conscience. So I think, and also, again, because unlike with religion clause, again, with press, we have this fallback protection of our speech clause, is that if we make a line drawing mistake, we're not putting anybody out in the cold. They are not being banished from our public debate. We have robust, important speech rights. We'll make sure that person can continue their dialogue and potentially, if it was an error, correct that error. And as for David, again, I do agree. His point about organizing our public dialogue is a very valuable contribution of the press, and he certainly makes a great point that there are a lot of other places we gather information. I would, I guess, maybe stick up for our reporters in the trenches that perhaps they are doing more news gathering that's still out there. There was just a New York Times article about the whole Chris Christie, Bridgegate, and how if it were not for just a bootstrapping local journalist who knew their traffic beat and started asking the right questions at the right time, we would likely have never heard of any of that. Maybe you think that's good, maybe that's bad, but we would not have heard about that. There was no government agency or nonprofit that was going to come and tell us that particular information. I also don't deny that individuals also fulfill these functions of both gathering and disseminating information and checking the government. My argument, however, is that the press does it in a particularly more effective way, an important way that is uniquely different from, I know you don't want me to use the word unique, but uniquely different from, like I said, just an army of people with megaphones that, we can have some of that effect, but not in the most efficient, effective way, which is what I believe was the purpose and intention behind having this special protection from the press clause. But I'll stop there because I know we all want to hear people's thoughts and comments.
So my question sort of builds on this notion of capture, right? Because I think the underlying assumption here is that the press is an unmitigated good in disseminating information and serving as a check on the powerful. And my question is, well, what if they don't? Right? What if they're not doing? What if things that we consider press aren't actually doing that? What if instead of informing the public, they're regularly and have a history of misinforming the public? And instead of acting as a check on the powerful, they're very closely allied with the powerful. So my question in terms of identifying the press is, do those considerations come into play? Do you also consider integrity and accuracy and independence when you're trying to decide whether something should be considered press entitled to special protections or not?
Well, I'll just start responding to that by saying that the court did tell us in Tornillo in particular that might be happening. They might not be doing their job well all of the time, but that it is not for the court to be making that judgment about whether the press is doing its job, that it's up to readers and reputation to protect those checks, which I think, again, suggests why we want not just the sporadic person coming up, but that if we're going to count on that accountability, we want to look for the people who are the repeat players and who have that expertise. We also have a history in our First Amendment law of, as we're here to celebrate, New York Times versus Sullivan, of creating breathing space for even false speech, even speech that doesn't quite hit the mark because we think there are higher values. So I would say that, of course, the press gets it wrong some of the time and doesn't do that. Ultimately, if they are doing it so wrong that they aren't fulfilling the press functions, then I think we would be dealing with a situation of a speaker who isn't the press, if it's that flawed in its function.
Yeah, I just wanted to chime in. I've been thinking about this question for another piece that I'm working on about the apparent trajectory of the court's characterizations of the press. So if you start at Sullivan and you work your way to today, the way that the court speaks of the press in dicta goes from these just sort of glowing kind of homily about how wonderful they are and how we would not be able to function as a citizenry without them, to sort of snide, not so valuable, we aren't so sure that they're serving any function that's unique or interesting or helpful kind of dialogue about them. And I think that your question is well placed. It's a question about, I think we can question whether this latest set of characterizations about the press are the court saying we don't think that the press is valuable and we no longer think that the press serves a valuable democratic function, or if it's the court saying we think that the press that we don't think anything different about the functioning of the press, or about the ideal functioning of the press. We just think you, the press, are no longer meeting that function, right? If it's a commentary on what they think of as a changing ability or the willingness of the press to rise to the occasion. And I think that's a question worth asking and digging into, because if it's simply the court changing its mind about a democratic role that it once believed an institution held and now suddenly it doesn't hold that, then that's really questionable to me. But if it's instead the court trying to make some sort of commentary on what it sees in real time happening, that there still is this fourth estate, but nobody's rising to the occasion of filling that role, then that's, I think, a very different line of analysis.
I actually think the press should be thinking differently about the press. If you take the Tornillo case, for example, the argument that the court made in Tornillo was, look, this is a case in which the candidate for public office sought space in a newspaper to reply to an attack on him and was denied. The Supreme Court said you can't force the newspaper to publish his reply. Well, I think that the question of access is far less acute today than it was then. At that time, he was seeking access in the Miami Herald. The court's opinion said, well, look, there are two newspapers. There's the Daily News and there's the Miami Herald. He can go to the Daily News, he can go to suburban newspapers or whatever. Well, today there's only the Miami Herald. But there are a million other outlets today. So you can't use the same rationale that the court used in Tornillo. So the question of access, I think, is less acute than it was then. The question of press abuse, let's say, is probably more acute today than it was then, simply because of the lack of competition and so on in certain spheres. But that too, I think, can be, I hope, is going to be remedied by the development of new outlets and the ease of entry. The barriers to entry that used to be huge for newspapers or magazines or television, the barriers of entry are very low today.
So I have to say I was baffled by this paper. It read to me a little bit more like a paper from 2004 or 1994 than 2014. You say function and technology, and yet there's no evidence of analysis of the implications of the past 5 years' massive reevaluation of the structure of the press, ranging from the Federal Trade Commission hearings and the Knight Foundation study through the public debate over the collapse of journalism and the future of journalism, down to the bills in Congress about reporter privilege that have competing definitions of precisely the question of what journalism is, and all the way to the literature on civic media and the network force study. All of which challenge at the very foundation the idea that you could come up with a nostalgic view of industry structure as your framework for a constitutional analysis. So, instead of going abstractly concrete, there's no question that by your 4 factors, the fashion and celebrity beat person at a mid-sized newspaper would be a journalist. But then let's look at 3 of it. So imagine that the judge in the Manning trial had excluded all but journalists and tried to exclude Alexa O'Brien, the volunteer who, with her Twitter feed, provided the most extensive, informed, contextualized analysis of the case as it was going on, and in the first few minutes after the sentencing, the most important source for understanding not only what was and was not the result of what it meant in terms of sentencing and how it compared to other. What if she were excluded? Is she part of your press? She doesn't seem to. What if you have a documentary filmmaker who over a couple of times in 5 years makes deeply critical documentaries, but is not otherwise? Is that a general commentator? And if Edward Snowden decides to hand over materials to Laura Poitras, is it okay to listen to her communications rather than to the NSA? And finally, if the kid who took photos of the pepper spray incident in UC Davis is prosecuted for criminal trespass, is that kid fundamentally different from someone employed by an organization? If a minister is a minister because the church says so, and that's your model, then the celebrity journalist is a journalist, but not the student. I don't understand on what conception of function one could plausibly look at 2 Supreme Court cases and believe they're creating a usable definition.
My definition of the press is the functional one. And I do push back on your argument that saying that it's because the press organization said. I said that is one proxy, one of many that can be used. But I completely agree that we need to be thinking. We have to be thinking functionally. That's why I think technology has shown us we have to be thinking functionally. For many of the examples that you gave me, that it's changing, it's going to continue and change. I'm sure in ways that at least I'll admit I can't imagine. Maybe some of you are better at imagining. And the court has said, as one of the reasons why they said we can't define the press is because any definition will be born in anachronism. And the court has used that as an excuse to not do it at all. So, but I completely agree that it's changing, and there are these concepts. But I will add the alternative is to not recognize it at all. So the kid who takes the pictures would be subject to criminal liability, without any protection. My thought is to be, maybe we can at least pick out some of the speakers, and we can have a lot of debate. I would love to have a lot of debate about the line and who those speakers are. I think they should be the people who are fulfilling these functions, and make sure they don't have criminal protection or criminal liability. But right now, they face that risk. Everybody does. In terms of access to, one of your examples, access to courtrooms. Now that, of course, Richmond newspaper gave that right to everybody, at least for criminal trials. And I also believe that, to me, if I were going to go forward with this, I would start the premise with, can this be a right or protection that we can give to everyone? If the answer is yes, we should give it to everyone. And it's only for that area of cases where the court uses as an example that we can't give it to everyone, so we're going to give it to no one, that we should think about, well, maybe there are some speakers who are using a function that fulfills a greater good, and think about giving a right or protection just to them. The classic example would be the court's cases about prisons and jails, where we say we can't let these journalists come in to look around because there's been, and talk to prisoners because there's been allegations of cruel punishment, of cruel and unusual conditions, and suicides by the inmate. And we say, well, we're running a jail here. We can't open our doors and let everybody in, so we let no one in. So my argument would be, maybe we could think about some speakers it would make sense to let in. And I do believe those speakers should be the people who are fulfilling these functions, and obviously, increasingly so, it's going to be people who do not work for traditional news organizations. It is bloggers, it is people on the Twitter feeds. How we draw those lines, I don't have a problem with looking at a history of having an audience and doing this regularly. That does mean there's going to be people who do it sporadically that don't fall into this category, but otherwise, the other option is nobody does. So at least I feel like it's a greater good to look for the people who are maximizing this effect for everyone by doing it regularly, investing resources, using expertise, reaching everyone, having an audience, and then we get more. So my goal is more constitutional rights, not less. But I agree completely that this concept is changing, and I don't deny that at all. And we need to make sure that any approach accepts that and understands that. Absolutely.
Yeah. Can I just follow up? I actually think that one of the causes of the tension here is that the court's Hosanna-Tabor model, although labeled a functional model, strikes me as a half-functional model. I think things like labeling, like self-identification or identification by an organization, I think labeling is by definition formalistic rather than functional. They might send us some clues, right? There might be aspects of that might send us some clues about the functional answers that we want about what is this person doing, what tasks is this person engaged in. But it's tricky because the way that Hosanna-Tabor actually labels it is in a purely identification mechanism. And I think that that's what drags us into this dialogue about nostalgic views of industry structure, because labeling is by definition that. The path dependency issue seems really stark in those areas.
My name is Chris Daly. I'm a professor at Boston University in the journalism department, so I'm coming from a different perspective. I research and teach about the history of journalism. And I want to thank you all for your thoughts here. I think you proved that this is a complicated area, and I don't myself have answers nailed down to every one of these questions. But I want to throw out a perspective from the revolutionary and early federal period. If we drill down into the historical materials and take some core samples from like 1775, 1780, 85, 90, and that was and we looked to get an idea of what the press was that the founders were thinking about. It's almost a fact-free zone. There was no news gathering function to speak of. There wouldn't be a professional or full-time news gatherer until the 1830s. So this was for the most part, it was a very polemical, partisan, argumentative kind of material, supplemented with poetry and letters and all kinds of grab bags of different things. But also there was a parallel kind of a press in the pamphlets of that era that were hit-and-run operations, almost always anonymous or pseudonymous. So you had a lot of the bulk of the press was basically a very DIY kind of an operation. printers ran these things, but the content came from all over the place, often, you know, anonymous or one-time only. There wasn't a, in other words, a full-time professional news gathering function that hadn't really shown up yet. And the debates around this basically amount to saying, well, this is pretty crappy and it doesn't serve us that well, but it's the best we have, and it's so important, even as polemical and partisan as it is, that we have to build in these protections for it. So, you know, I think that has some bearing on some of our contemporary attempts to get handles and definitions on a new DIY, very polemical kind of press.
I'll say that whatever, if we do choose to try to define the press, one thing I think is clear that should be not part of it is a requirement of objectivity, and for a lot of the reasons that you said, you know, including that it will be impossible to enforce and it probably doesn't exist, but also because you're right, we have this history of, you know, completely partisan press. So I agree that is, you know, we don't need. That's not what we're going for. So this idea of objectivity and among our press is not. And as far as you're right about the pamphleteers or the sort of do-it-yourself, and you know, it seems quite obvious that the modern analogy are bloggers. And I think people will ask me all the time about bloggers, and I think the answer is some of them are fulfilling these functions of the press. They publish regularly with established audiences. They newsgather. They find things, and others are not. Others are go, and they're sort of one shop, like you said. They come out with one thing. But what I'd say about the second group is they're very protected in their speech rights. They go out and publish, and they have, you know, bless them, they have lots of protection here, and I think rightly so. Another reason not to worry about it, and they probably wouldn't actually even use the type of rights we're talking about very much. It's the repeat players are the ones who are doing more of this kind of work and would actually use the things. And we all, you know, still get to have our speech rights, and I think very importantly so.
Can I respond to that the historical point? Obviously, there was no news gathering operation. There were no professional journalists at the time of the framing. I think, though, that what printers did was to provide a catalyst for community. If you look at the newspapers of the time, if you look at the debates in the various fora in which press clauses, all of the colonies had press clauses before there was a First Amendment, and the discussions about those. What was valued was the existence of a mechanism in which people could come together and debate things. Now, they may have been highly partisan debates. The printer may have been highly selective in whose contributions he accepted, but they were highly valued. You know better than I do, Benjamin Franklin funded and supplied the mechanisms and everybody for printers all up and down the eastern seaboard. Communities, in some respects, a community didn't really exist until it had a newspaper of some kind. You think about the frontier. What were the first businesses that developed in frontier communities? You know, I suppose a whorehouse and a saloon first, and then a newspaper. So it's been a felt need, at least, since I think the time of the framing.
Sorry, I can't hear you.
One question I have is, I think the functional definition of the press is a really interesting one, and obviously today we've heard that there are many different functions that the press serves. So my question, and this is a little bit outside the scope of the paper, but I was wondering, in terms of the protections that the press receives, do you think the different outlets or different entities within the press would receive different protections depending on the functions that they are serving? In other words, if we define press as what they can do for us, then give their protections, but also depend on what they're doing.
Absolutely. I think that, and again, you know, going into the details of sort of what those press clause rights might look like and how we would, you know, frame them is farther down the line, assuming anyone ever jumps on board my little train here. But I think that makes total sense. I think looking at sort of this match between the two, and that would mean, like you said, different, perhaps looking differently at different speakers. I think does make sense.
Huh. That's interesting. we out of time?
This could be a great embarrassment because this question comes from almost total ignorance of the scholarship in this area, but I was sort of started to think about this by the question here and the description of how publications in the colonial period are so different from what we now think of as the press. Could it be that the speech and press clauses were really just a way for framers to distinguish speech, literally, oral, from anything that's published, that's in writing? So include not only journalism, broadsides, books, anything published. Is that maybe the only difference?
Can I respond
Yeah,
to
please.
that? I think that the history shows the opposite. I've forgotten the exact numbers, but I believe it's true that all of the colonial, or the first state constitutions, which preceded the federal constitution by a few years, all of them protected freedom of the press. Only 2 of them protected freedom of speech. So I think the original impulse was freedom of the press. Speech came later.
But you're not alone in thinking that. Eugene Volokh pretty compellingly argued, right, sort of went to the task of digging up as much evidence from the time of the founding as possible about the press clause being purely a sort of technological speaking versus pressing. Mike McConnell recently has sort of jumped on board of that in thinking about the ramifications of Citizens United. He sort of adopted Eugene's position. And I think that Sonja's work requires us to take 2 steps, right? This paper requires us to embrace the first paper, which is that the press clause stands for something meaningful aside from a technological protection, and therefore envisions an entity called the press. And this second paper requires us to fill in that identity. If there is a press that is protected, who is it? And I think that there is significant ongoing debate as to both questions.
Or, you could just say original intent does not tie us down
Right.
to what they thought.
Yeah, I would say Justice Scalia would agree with you, and he and Justice Stevens in Citizens United kind of go back and forth a little bit about this point. And I will add, and I'm actually working on a paper trying to put some of this together, which I'm hoping will be out this spring. But I also add into the equation what the court has done with the speech clause in the last 100 years, which has been interpreted so broadly that I think it's hard to read without it having an inclusion of a right to reach an audience through publication and dissemination as not being part of our speech rights as well. And if you take that into account, it would leave the press clause with little to nothing to do, which is how the court has sort of looked at it.
Okay, thank you all, and we'll break and reconvene at 1:10 for the next panel. Thank you.